Art. We have heard Sri Deep Chand Singh learned counsel for the contesting respondents, and we find that the appeal deserves to succeed on both grounds. Star. The issuance of a writ of certiorari is in the exercise of powers under Article 226 of the Constitution of India. Star. A writ of certiorari is issued in order to put the records straight and to correct an error which is brought before the court for its consideration in the exercise of jurisdiction under Article 226 of the Constitution of India. Star. The exercise of powers therefore is not dependent upon annexing or not annexing the document but is dependent upon the existence of the record before the court. Star. The source of the record, no doubt, if is being made a matter of challenge, is the primary duty of the petitioner to place it on record, but if for some reason if the same has been brought on record by a contesting respondent and is available before the court, then the court cannot ignore it merely on the ground that it did not form part of the paper book of the writ petition. Stop para. In the instant case, we find that a writ of certiorari has been sought for quashing the select list and an amendment was sought which was allowed on 7th December, 2012. Stop. The order passed by the learned single judge allowing the amendment application is extracted herein under para code. Heard learned counsel for the petitioner. Stop para. The amendment application is allowed. Stop para. Learned counsel for the petitioner may carry out necessary amendment within a week. Stop para. Newly amended petitioners may file reply to the amended writ petition within the same period. Stop D code para. The document was very much on the record. Stop. In this view of the indisputable facts, we see no reason for the learned single judge to have refused to exercise judicial discretion in the exercise of powers under Article 226 of the Constitution of India when the document which was sought to be quashed was on record of the court. Staff. The issue was considered in the case of S. Barrow (Supra), on which reliance has been placed by the learned counsel for the appellant, and in order to substantiate the conclusions drawn herein above, we extract herein under para 18 of the said judgment para code. The learned Advocate General asked us to refuse to set aside the impugned order, as it would revive an order which is in contravention of the Constitution itself. Stop. We, however, think that we should not allow an order, passed without jurisdiction, to stand, because all proceedings consequent to that order would also be without jurisdiction. Stop. The better course, in our opinion, would be to quash both the orders with the result that the land acquisition officer would now proceed to determine compensation unhampered by any one of them. Stop.